Hi, it's Quasey Smith, office managing partner here at Smith & Green Attorneys at Law, located here in Phoenix, Arizona. I just wanted to come and talk to you about something recently that a client asked me. Again, we have hundreds and hundreds of clients that we represent, and they often ask this question, particularly about civil cases that we represent, civil litigation cases, car accidents, wrongful terminations, medical malpractice, wrongful death, all of those civil rights litigation that we have. They say, well, what are the stages of my case, of this civil case? How is this thing going to progress through court? Because the truth be told, that this is a very scary process, this whole courtroom thing. Now, granted, this is our mock courtroom in our office where we trial prep with our clients and whatnot. But when you go downtown to the courthouse, they're a whole lot bigger than this. Federal courts are a whole lot bigger than this. And people want to know, what can I expect through the stages of my case? How is it going to go? There are huge books. Here's one of them, Rules of the Court. That's what this is. These are rules that mark and demark the stages that your case has to go through. They are for federal court and they are for civil court. And I'm particularly talking about the Arizona cases and some of the federal cases, regardless of the circuit that you are in. Then there are these rules, and then there are local rules that apply to the courts, and there's so many different variations. But broadly speaking, what happens with your case is, first of all, you must file a timely lawsuit. You have to pay attention to the statute of limitations on your case. A statute of limitation is a fancy legal way of saying you only have a certain amount of time to file a lawsuit regarding what you feel has happened to you in violation of the law. If you let that statute of limitation run, it is a bar to filing that lawsuit. The court won't even accept jurisdiction of it because the lawsuit would be considered untimely. So after you file a timely lawsuit, you file a complaint, as sometimes it's called, or a lawsuit, or petition in a divorce matter or some other matter, same thing. When you file that, then you have to serve that complaint. Particularly like in Arizona, you have to serve that complaint within 90 days of filing the lawsuit. If it's a family law matter like a divorce or something like that, you generally have 120 days to file it. But this is going to be different depending on what court you're in and what jurisdiction you're in. You're going to have a certain amount of time to serve that complaint. Serving that complaint has to be served in accordance to the rules. Sometimes it takes a process server. Sometimes you can send it certified mail. You're going to need to talk with an attorney so that you know how that complaint needs to be served. The third thing that happens is then there is an answer filed to that complaint, or a response to a petition. That is the other person, whoever it is that you're suing, they get a certain amount of time to respond to it. For example, like according to this rule book that I just showed you in Arizona, generally, if you're served with your complaint in state, you got 20 days to respond to it. If you're served out of state, you have 30 days to respond to it. If you sign this little paper that we call a waiver of service, so they don't have to go through the expense of hiring a process server, then the state rules, they'll give you 60 days to respond to the complaint. So it could vary depending on how and where you were served, or if you waived service. But the complaint has to be served and you have to respond to it within the specified time frame. If you don't, that's when that bad D word comes up, default. The party that's suing could file a default against you and get what they asked for if you don't respond to the default. Then there are other things that happen in the process. You can petition to remove the complaint to another court. Say, for instance, if I file a civil rights action under the federal constitution in state court, we could request it be removed to federal court. That's all a process that way too much information for you. Your attorney's going to have to deal with it, and that's why you need to talk to a lawyer. One of the big mistakes I see folks make that feel like they have a case is they think they can do it on their own. We've been to school for a number of years. We've spent hours training, ongoing, reviewing law. This is not something you should try to do on your own. You need a lawyer to talk to. You need to find the best lawyer for you, because after you get this thing filed, then you enter into what we call discovery, where you're switching evidence and whatnot and deposing people and stuff. This is all before you get to trial. And so there's quite a lengthy process. How long is this going to take? Depends on your case, depends on how you schedule things out to be done. And so you need to talk with your lawyer, discuss all of these things, because there are things that can be taken into consideration. Your family, resources, all of that stuff. So you need to talk to a good lawyer. You can call our office. We're more than welcome to speak with you about your case. And should we become the counsel of record for you, obviously we'll go over all of these things with you. But it's always important to start out on the right foot, to get things going in the right way up front, so that you can get the best possible outcome in the future. Call a good lawyer, and let's get your case on the road.